Clients often call wondering how they can void a will that they feel doesn't represent their loved one's true intent. Whether you call it voiding a will, disputing a will, challenging a will, contesting a will, or invalidating a will, these all simply mean the court process by which a beneficiary named in a will, or an heir who is not named, seeks to set aside, invalidate, a document they believe should not dictate how their loved one's affairs should be handled. Yes, you can challenge a will in California. In fact, it's a lot more common than you might think. Of course, you will need a basis for doing so. Dissatisfaction with the gift you did or did not receive is not necessarily a basis for disputing a will. We talk about some of the good reasons for contesting a will later on. The answer to this question depends on the facts of your case. For example, if you are an heir of the deceased, son, daughter, spouse, parent, then you very likely have the ability to pursue a will contest. If you are not an heir, but you were a beneficiary under a previous version of the will, for example, one that gave you a more valuable inheritance than what you're getting now, then you too will have the authority to dispute the will. First, you should consult an experienced will contest attorney who can help you examine the facts of your case. An expert will contest attorney will be able to advise you whether your case should be pursued from both an emotional and a financial standpoint. Second, file a petition contesting the will in the county court where your loved one resided. Third, work with your will contest attorney to discover other helpful information and witnesses that can help you prove your case and secure a favorable result. Lastly, after you've obtained all the information you need and are ready to start your will contest trial with the court, but remember, most courts will strongly encourage the parties to try and settle, either through a mandatory settlement conference, the probate volunteer settlement officer program, or mediation with a retired probate judge. You're ready to go to trial and have a court determine your case. Your probate litigation attorney can help you decide which path is right for you. Asserting legal claims to contest a will should be done with the assistance of an experienced probate litigation attorney who can ensure that your claims are set forth fully and completely to present your best case to the judge and the court. Here are some of the most common bases for disputing a will. Voiding a will for incapacity. The most common basis for disputing a will is that the person who created it was suffering from dementia, Alzheimer's dementia, had had a stroke, etc. This is known as a capacity or an incapacity claim to void a will. It essentially means that the person who is incapable of understanding what he or she was doing, and therefore the court should cancel the will. A second basis is voiding a will for undue influence or coercion. Undue influence, commonly called coercion, claims are the second most popular basis for a will contest. Undue influence essentially means that the person did not create the will of their own free act. Instead, they were pressured into creating the document or giving a gift to someone. And if they had not been pressured, they wouldn't have done it. The influencer can be a spouse, often a step-parent, a child who's often serving also as a caregiver to the parent, a member of the clergy, or frankly anyone who has access to someone who needs their services and doesn't have the ability to resist what they're being asked for. These claims often go hand in hand with incapacity claims because incapacity lessens the person's ability to resist that influence. The third most common type of claim is will fraud, including forged wills. While less common than the other claims, there is a cottage industry of will handwriting experts and document examination experts who exist solely because of the number of doctored or forged wills. An experienced probate litigation attorney will have these connections and will have worked with these experts and can help you determine whether your will is a fraud. A will must be probated, or otherwise known as administered, through the county probate court in the county in which your deceased loved one resided. Once a will has been filed for probate, the county probate court will set a hearing date that creates deadlines by which you need to file your will contest petition. You need not wait until the questionable will has been filed for probate, but you will need a copy of the will. You should consult a competent will contest attorney who can help make sure you don't miss your deadline to file your will contest. Most states do not enforce no contest clauses. California is the exception. Two things to understand here are: one, the no contest clause likely will not be enforced if you have probable cause to contest the will. And two, if you are disinherited in the will that you're challenging, you have nothing to lose because you aren't getting anything under the challenged will anyway. These issues should be examined in consultation with a probate dispute attorney to ensure you do not inadvertently trigger a no contest clause. Normally, we recommend working with a will contest lawyer familiar with the county probate court where your loved one resided. For example, if your decedent lived in Los Angeles, we recommend working with a Los Angeles will litigation attorney, even if you live elsewhere. Choosing a will contest lawyer is an important decision. At RMO Lawyers, we help people like you every day, and the consultation's always free. Just email us at hello@rmolawyers.com. Thanks for watching.